Innalhamdulillah wassalatu wassalamu ala rasulillah Sayyidina Muhammad ibn Abdillah wa ala alihi wa bihi wa mala amma ba'du. First, I would like to say thank you to Mr. S. Parman SHMH as a lecturer in International Criminal Law courses. Let me to introduce myself. My name is Ganas Rapina Cahya. I am majority in Faculty of Law, Islamic University of Riau. On this occasion, I would like to present about the definition and history of international criminal law and international criminal court jurisdiction. First, I will explain about the definition of international criminal law. Based on Blacklaw's dictionary, international criminal law is a grave breach of international law, such as genocide or a crime against humanity, made a punishable offense by a treaties or applicable rules of customary international law. An international criminal occurs when three conditions are satisfied. First condition is the international norm must derive either from customary international law or from customary international law and must have direct binding force on individuals without intermediate provision of municipal law. The provisions must be made for the prosecution of acts penalized by international law in accordance with the principle of universal jurisdiction. And the last is a treaty establishing liability for the act must be in the great majority of countries also termed in international offense. International criminal law is a body of public international which is designed to prohibit certain categories of conduct commonly viewed as a serious treaties, and to make perpetrators of such conduct criminally accountable for their perpetration. The core crimes under international law are genocide, war crimes, crimes against humanity, and the crime of aggression. International criminal law is a set of legal rules and principles governing international crimes committed by its legal subjects in order to achieve a specific goal. The goal is usually concerned with the politics of a country. The rules and principles of international criminal law are the rules and principles of law that can be found in the form of international treaties, whose substance regulates international crime. The rules of international criminal law based on the history of international criminal law were born since the Treaty of Westphalia in 1648. Within this treaty began to burn the principles of independence, sovereignty of decrees of each state, and the right of self-determination, which later developed into the rights and obligations of the state. In Article 38, Section 1 of the Statute of International Tribunal, we can formally review the rules and international criminal law, which explain that a tribunal whose duty is to render decision in accordance with international forecasts brought against it. The international tribunal law shall use first, international treaties of a general or special nature, which contain legal provisions expressly recognized by the countries in the dispute. International custom as evidence of the existence of a common custom that has been accepted as law. Next, general legal principles recognized by civilized nations. And court decision, the teaching of the most prominent scholars from various countries as an additional course for establishing legal methods. Based on above rules, basically, the purpose of regulating in international criminal law is basically not much different from the objectives to be achieved by the regulation of criminal law, namely related to issues related to the interests of security, order, and peace of the international community. This rule concerning justice, security, and order and peace of the international community are jus jugens. Jus jugens is applicable to the entire international community. The rules in international criminal law are still not codified because no state about that the state can force other countries to submit to his international criminal law because of the principle equality of degrees in international criminal law. Therefore, in international criminal law, it is necessary to pay attention to the applicable principles because the principles have an impact on the application and implementation of criminal law. The next is history of international criminal law. International criminal law was born after the end of World War II. Classical international law governs the relationship, his rights and responsibilities of the states. But after World War II, the Charter of International Military Tribunal and Nuremberg Trial revolutionized international law by applying the prohibition directly to individuals. In this case, the defeated leaders of Nazi Germany thus inventing international criminal law. After German for decades, international criminal law was revived in the 1990s to address the war crimes in the Yugoslavia wars and Rwanda genocide, leading to the establishment of a permanent international criminal court in 2001. After the success of two ad hoc international criminal courts, various other ad hoc international criminal courts based on United Nations Security Council resolutions were established, namely through the International Criminal Tribunal for the former Yugoslavia in 1993. Based at The Hague, Netherlands, and there was also International Criminal Tribunal for Rwanda in 1994, located in Arusha, Tanzania. International criminal law is recognized as a new discipline in the legal world since the end of the Second World War, around 1945. International criminal law is a developing inseparable from the growing International Criminal Act. But if you look at the long history of international criminal law existed long before modern civilization as it today. At first, international criminal law narrowly only discussed crimes surrounding work aimed at controlling the land and wealth of the people by tribes that won war over tribes that suffered defeated in war. Organizational structure of the International Criminal Court. The organizational structure the International Criminal Court has been set out in Article 34 of the Rome Statute of 1998, which consists of first, presidency, second, as appeal divisions, trial division, and pre-trial division, third, and the office of the prosecutor, and the last is registry. The presidency has a full role in carrying out duties related to cases in this court. Article 35, Section 2 confirms that the judge comprising the presidency shall serve on a full-time basis as soon as they elected, which means that the judges of tribunals shall perform their duties or work full-time after being declared elected as judge of the court. The presidency is responsible for the overall administration of the courts and the affairs of the other organs of the ICC, with its exception of the office of the prosecutor. The composition of International Criminal Court judges is divided into three parts, led by three judges consisting of one president and two vice presidents, namely the president of the court, the first vice president, and second vice president. And the next is the judicial divisions. The judicial division is a division in the International Criminal Court. After the completion of the selection of court judges who carry out their duties and responsibilities under Article 13 9 paragraph 1 of the Rome Statute of 1998, which states that each judge in the tribunal is responsible for presiding over the courts and proceedings in accordance with its divisive authority. The fictional arrangement contained in the International Criminal Court are regulated in Article 99, paragraph 1 of the Rome Statute, which consists of first, athlete division consisting of a chairman president with 4 member judges. Second, the judicial division consists of no less than 6 judges, and the last is the pre-trial divisions consists of no less than 6 judges. The office of the prosecutor is headed by a prosecutor elected by the member states with a term of 9 years and cannot be reappointed. The existence of the office of the prosecutor is separate from the court because it is independent in the performance of its duties. The office of the prosecutor is responsible for receiving, substantiating submissions and information about crimes within the court's jurisdiction, to then conduct investigations and prepare precedents before trial. Prosecutors in the sections may act on submission from the state or through the United Nations Security Council and may also be conducted to their own initiative or conduct investigations of their own accord or proprio motu. Based on information and documents of submission of the case concerning crimes within the jurisdictions of international in the section may act on submissions from the state or through the United Nations Security Council and may also be conducted of their own initiative or conduct investigations of their own accord proprio motu based on information and documents of submissions of cases concerning crimes within the jurisdiction of International Criminal Court. And the last is the registry. Clerkship is regulated in Article 43 in Rome Statute. Article 43, paragraph 1 of the Rome Statute states that registrar's office has the responsibility to carry out these main duties into the administrative, non-judicial, and service files of the International Criminal Court. Those who can become members of the Secretariat are participating countries that have received recommendation from United Nations General Assembly. The registrar works full-time for a term of 5 years, and then they can be re-elected with a one-time limit. This is as confirmed in Article 43, paragraph 5 of the Rome Statute. And the next is Article 43, paragraph 2, explain. Article 43, paragraph 2 explains that the registrar's office is headed by a clerk who is the main administrative officer of the International Criminal Court and carries out its functions under the authority of the chairman of the International Criminal Court. Article 43, paragraph 6 states that in carrying out their duties, the court unit forms the unit within the court unit itself, such a victim, the international unit, and witness unit. This is done to assist the International Criminal Court or judges in carrying out their duties to try the perpetrators of international crime. This unit was provided after consultation with the Office of the Prosecutor. And finally, I would like to finish this presentations. Thank you so much for watching my video. Wassalamualaikum warahmatullahi wabarakatuh.